Republic Act No. 8799. The Securities Regulation Code. Be it enacted by the Senate and the House of Representatives of the Philippines in the Congress assembled. Chapter I. Title and Definitions. Section 1. Title. This shall be known as the Securities Regulation Code. Section 2. Declaration of State Policy. The state shall establish a socially conscious, free market that regulates itself, encourage the widest participation of ownership in enterprises, enhance the democratization of wealth, promote the development of the capital market, protect investors, ensure full and fair disclosure about securities, minimize if not totally eliminate insider trading and other fraudulent or manipulative devices and practices which create distortions in the free market. To achieve these ends, this Securities Regulation Code is hereby enacted. Section 3. Definition of terms. 3.1. Securities are shares, participation, or interests in a corporation or in a commercial enterprise or profit-making venture and evidenced by a certificate, contract, instruments, whether written or electronic in character. It includes a. Shares of stocks, bonds, debentures, notes, evidences of indebtedness, asset-backed securities. b. Investment contracts, certificates of interest or participation in a profit-sharing agreement, certifies of deposit for a future subscription. c. Fractional undivided interests in oil, gas, or other mineral rights. d. Derivatives like option and warrants. e. Certificates of assignments, certificates of participation, trust certificates, voting trust certificates or similar instruments. f. Proprietary or non-proprietary membership certificates in corporations, and g. Other instruments as may in the future be determined by the Commission. 3.2. Issuer is the originator, maker, obligor, or creator of the security. 3.3. Broker is a person engaged in the business of buying and selling securities for the account of others. 3.4. Dealer means many person who buys/sells securities for his/her own account in the ordinary course of business. 3.5. Associated person of a broker or dealer is an employee therefore whom, directly exercises control of supervisory authority, but does not include a salesman, or an agent or a person whose functions are solely clerical or ministerial. 3.6. Clearing agency is any person who acts as intermediary in making deliveries upon payment effect settlement in securities transactions. 3.7. Exchange is an organized marketplace or facility that brings together buyers and sellers and executes trade of securities and/or commodities. 3.8. Insider means, a. the issuer, b. a director or officer, or any person performing similar functions, of, or a person controlling the issuer, gives or gave him access to material information about the issuer or the security that is not generally available to the public. d. A government employee, director, or officer of an exchange, clearing agency and/or self-regulatory organization who has access to material information about an issuer or a security that is not generally available to the public, or e. a person who learns such information by a communication from any foregoing insiders. 3.9. Pre-need plans are contracts which provide for the performance of future services of or the payment of future monetary considerations at the time actual need, for which plan holders pay in cash or installment at stated prices, with or without interest or insurance coverage, and includes life, pension, education, interment, and other plans which the Commission may from time to time approve. 3.10. Promoter is a person who, acting alone or with others, takes initiative in founding and organizing the business or enterprise of the issuer and receives consideration therefor. 3.11. Prospectus is the document made by or on behalf of an issuer, underwriter, or dealer to sell or offer securities for sale to the public through registration statement filed with the Commission. 3.12. Registration statement is the application for the registration of securities required to be filed with the Commission. 3.13. Salesman is a natural person, employed as such as an agent, by a dealer, issuer, or broker to buy and sell securities. 3.14. Uncertificated security is a security evidenced by electronic or similar records. 3.15. Underwriter is a person who guarantees on a firm commitment and/or declared best effort basis the distribution and sale of securities of any kind by another company. Chapter 2. Securities and Exchange Commission. Section 4. Administrative Agency. 4.1. This code shall be administered by the Security and Exchange Commission, hereinafter referred to as the Commission, as a collegial body, composed of a chairperson and 4 commissioners, appointed by the President for a term of 7 years each, and who shall serve as such until their successor shall have been appointed and qualified. A commissioner appointed to fill a vacancy occurring prior to the expiration of the term for which his/her predecessor was appointed, shall serve only for the unexpired portion of their terms under Presidential Decree No. 902A. Unless the context indicates otherwise, the term commissioner includes the chairperson. 4.2. The commissioners must be natural-born citizens of the Philippines, at least 40 years of age for the chairperson and at least 35 years of age for the commissioners, of good moral character, or unquestionable integrity, of known probity and patriotism, and with recognized competence in social and economic disciplines, provided that the majority of commissioners, including the chairperson, shall be members of the Philippine Bar. 4.3. The chairperson is chief executive officer of the Commission. The chairperson shall execute and administer the policies, decisions, orders, and resolutions approved by the Commission, and shall have the general executive direction and supervision of the work and operation of the Commission and its members, bodies, boards, offices, personnel, and all its administrative business. 4.4. The salary of the chairperson and the commissioners shall be fixed by the President of the Philippines based on the objective classification system, at a sum comparable to the members of the Monetary Board and commensurate importance and responsibilities attached to the position. 4.5. The Commission shall hold meetings at least once a week for the conduct of business, or as often as may be necessary upon the call of the chairperson or upon the request of 3 commissioners. The notice of the meeting shall be given to all commissioners, and the presence of 3 commissioners shall constitute a quorum. In the absence of the chairperson, the most senior commissioner shall act as presiding officer of the meeting. 4.6. The Commission may, for purposes of efficiency, delegate any of its functions to any department of office of the Commission, an individual commissioner or staff member of the Commission, except its review or appellate authority and its power to adopt, alter, and supplement any rule or regulation. The Commission may review upon its own initiative or upon the petition of any interested party any action of any department or office, individual commissioner, or staff member of the Commission. Section 5. Powers and Functions of the Commission. 5.1. The Commission shall act with transparency and shall have the powers and functions provided by this Code, Presidential Decree No. 902A, the Corporation Code, the Investment Houses Law, the Financing Company Act, and other existing laws. Pursuant thereto, the Commission shall have, among others, the following powers and functions. A. Have jurisdiction and supervision over all corporations, partnership, or associations who are the grantees of primary franchises and/or a license or a permit issued by the government. B. Formulate policies and recommendations on issues concerning the securities market, advise Congress and other government agencies on all aspects of the securities market, and propose legislation and amendments thereto. C. Approve, reject, suspend, revoke, or require amendments to registration statements, and registration and licensing applications. D. Regulate, investigate, or supervise the activities of persons to ensure compliance. E. Supervise, monitor, suspend, or take over the activities of exchanges, clearing agencies, and other SRAs. F. Impose sanctions for the violation of laws and rules, regulations, and orders, and issued pursuant thereto. G. Prepare, approve, amend, or repeal rules, regulations and orders, and issue opinions and provide guidance on and supervise compliance with such rules, regulation, and orders. H. Enlist the aid and support of and/or deputized any and all enforcement agencies of the government, civil or military, as well as any private institution, corporation, firm, association, or person in the implementation of its powers and function under its code. I. Issue cease and desist orders to prevent fraud or injury to the investing public. J. Punish for the contempt of the Commission, both direct and indirect, in accordance with the pertinent provisions of and penalties prescribed by the rules of court. K. Compel the officers of any registered corporation or association to call meetings of stockholders or members thereof under its supervision. L. Issue subpoena duces tecum and summon witnesses to appear in any proceedings of the Commission, and in appropriate cases, order the examination, search, and seizure of all documents, papers, files and records, tax returns, and books of accounts of any entity or person under investigation as may be necessary for the proper disposition of the cases before it, subject to the provisions of existing laws. M. Suspend, or revoke, after proper notice and hearing, the franchise or certificate of registration of corporations, partnership, or associations, upon any of the grounds provided by law, and N. Exercise such other powers as may be provided by law, as well as those which may be implied from, or which are necessary or incidental to the carrying out of, the express powers granted the Commission to achieve the objectives and purposes of these laws. 5.2. The Commission's jurisdiction over all cases enumerated under Section 5 of Presidential Decree No. 902A is hereby transferred to the Courts of General Jurisdiction or the appropriate regional trial court, provided that the Supreme Court, in the exercise of its authority, may designate the regional trial court branches that shall exercise jurisdiction over the cases. The Commission shall retain jurisdiction over pending cases involving intracorporate disputes submitted for final resolution, which should be resolved within 1 year from the enactment of this code. The Commission shall retain jurisdiction over pending suspension of payment/rehabilitation cases filed as of June 30, 2000 until finally disposed. Section 6. Indemnification and Responsibilities of Commissioners. 6.1. The Commission shall indemnify each Commissioner and other officials of the Commission, including personnel performing supervision and examination functions, for all cost and expenses reasonably incurred by such persons in connection with any civil or criminal actions, suits, or proceedings to be liable for gross negligence or misconduct. In the event of settlement or compromise, indemnification shall be provided only in connection with such matters covered by the settlement as to which the Commission is advised by external counsel that the persons to be indemnified did not commit any gross negligence or misconduct. The costs and expenses incurred in defending the aforementioned action, suit, or proceeding may be paid by the Commission in advance of the final disposition of such action, suit, or proceeding upon receipt of an undertaking by or on behalf of the Commissioner, officer, or employee to repay the amount advanced, should it ultimately be determined by the Commission that he/she is not entitled to be indemnified as provided in this subsection. 6.2. The Commissioners, officers, and employees of the Commission who willfully violate this code, or who are guilty of negligence, abuse, or acts of malfeasance, or fail to exercise extraordinary diligence in the performance of their duties, shall be held liable for any loss or injury suffered by the Commission or other institutions such as a result of such violation, negligence, abuse, or malfeasance, or failure to exercise extraordinary diligence. Similar responsibility shall apply to the Commissioners, officers, and employees of the Commission for 1. The disclosure of any information, discussion, or resolution of the Commission of a confidential nature, or about the confidential operations of the Commission, unless the disclosure is in connection with the performance of official functions with the Commission or prior authorization of the Commissioners, or 2. The use of such information for personal gain or to the detriment of the Government, the Commission, or third parties, provided, however, that any data or information required to be submitted to the President and/or Congress or its appropriate committee, or to be published under the provisions of this code, shall not be considered confidential. Section 7. Reorganization. 7.1. To achieve the goals of this code, consistent with the civil service laws, the Commission is hereby authorized to provide for its reorganization, to streamline its structure and operations, upgrade its human resource component and enable it to more efficiently and effectively perform its functions and exercise its power under this code. 7.2. All positions of the Commissions shall be governed by a compensation and position classification system and qualification standards approved by the Commission based on comprehensive job analysis and audit of actual duties and personal responsibilities. The compensation plan shall be comparable with the prevailing compensation plan in the Banco Central ng Pilipinas and other government financial institutions and shall be subject to periodic review by the Commission no more than once every 2 years without prejudice to yearly merit review or increases based on productivity and efficiency. The Commission shall, therefore, be exempt from laws, rules, and regulations on compensation, position classification and qualification standards. The Commission shall, however, endeavor to make its system conform as closely as possible with the principles under the Compensation and Position Classification Act of 1989, Republic Act 6758, as amended. Chapter 3. Registration of Securities. Section 8. Requirement of registration of securities. 8.1. Securities shall not be sold or offered for sale or distribution within the Philippines, without a registration statement duly filed with and approved by the Commission. Prior to such sale, information on the securities, in such form and with such substance as the Commission may prescribe, shall be made available to each prospective purchaser. 8.2. The Commission may conditionally approve the registration statement under such terms as it may deem necessary. 8.3. The Commission may specify the terms and conditions under which any written communication, including any summary prospectus, shall be deemed not to constitute an offer for sale under this section. 8.4. A record of the registration of securities shall be kept in Register Securities in which shall be recorded orders entered by the Commission with respect such securities. Such register and all documents or information with the respect to the securities registered therein shall be open to public inspection at reasonable hours on business days. 8.5. The Commission may audit the financial statements, assets, and other information of firm applying for registration of its securities whenever it deems the same necessary to ensure full disclosure or to protect the interest of the investors and the public in general. Section 9. Exempt securities. 9.1. The requirement of registration under subsection 8.1 shall not as a general rule apply to any of the following classes of securities. A. Any security issued or guaranteed by the Government of the Philippines, or by any political subdivision or agency thereof, or by any person controlled or supervised by, and acting as an instrumentality of said government. B. Any security issued or guaranteed by the government of any country with which the Philippines maintains diplomatic relations, or by any state, province, or political subdivision thereof on the basis of reciprocity, provided that the Commission may require compliance with the form and content for disclosures the Commission may prescribe. C. Certificates issued by a receiver or by a trustee in bankruptcy duly approved by the proper adjudicatory body. D. Any security or its derivatives the sale or transfer of which, by law, is under the supervision and regulation of the Office of the Insurance Commission, Housing and Land Use Rule Regulatory Board, or the Bureau of Internal Revenue. E. Any security issued by a bank except its own shares of stock. 9.2. The Commission may, by rule or regulation after public hearing, add to the foregoing any class of securities if it finds that the enforcement of this code with respect to such securities is not necessary in the public interest and for the protection of investors. Section 10. Exempt transactions. 10.1. The requirement of registration under subsection 8.1 shall not apply to the sale of any security in any of the following transactions. A. At any judicial sale, or sale by an executor, administrator, guardian, or receiver or trustee in insolvency or bankruptcy. B. by or for the account of a pledge holder, or mortgagee, or any of a pledge lien holder selling of offering for sale or delivery in the ordinary course of business and not for the purpose of avoiding the provision of this code, to liquidate a bona fide debt, a security pledged in good faith as security for such debt. C. An isolated transaction in which any security is sold, offered for sale, subscription, or delivery by the owner therefore, or by his representative for the owner's account, such sale, or offer for sale, subscription or delivery not being made in the course of repeated and successive transaction of a like character by such owner, or on his account by such representative and such owner or representative not being the underwriter of such security. D. The distribution by a corporation actively engaged in the business authorized by its articles of incorporation, of securities to its stockholders or other security holders as a stock dividend or other distribution out of surplus. E. The sale of capital stock of a corporation to its own stockholders exclusively, where no commission or other remuneration is paid or given directly or indirectly in connection with the sale of such capital stock. F. The issuance of bonds or notes secured by mortgage upon real estate or tangible personal property, when the entire mortgage together with all the bonds or notes secured thereby are sold to a single purchaser at a single sale. G. The issue and delivery of any security in exchange for any other security of the same issuer pursuant to a right of conversion entitling the holder of the security surrendered in exchange to make such conversion, provided that the security so surrendered has been registered under this code or was, when sold, exempt from the provision of this code, and that the security issued and delivered in exchange, if sold at the conversion price, would at the time of such conversion fall within the class of securities entitled to registration under this code. Upon such conversion the par value of the security surrendered in such exchange shall be deemed the price at which the securities issued and delivered in such exchange are sold. H. Broker's transaction, executed upon customers' orders, on any registered exchange or other trading market. I. Subscriptions for shares of the capital stocks of a corporation prior to the incorporation thereof or in pursuance of an increase in its authorized capital stocks under the Corporation Code, when no expense is incurred, or no commission, compensation, or remuneration is paid or given in connection with the sale or disposition of such securities, and only when the purpose for soliciting, giving, or taking of such subscription is to comply with the requirements of such law as to the percentage of the capital stock of a corporation which should be subscribed before it can be registered and duly incorporated, or its authorized capital increase. J. The exchange of securities by the issuer with the existing security holders exclusively, where no commission or other remuneration is paid or given directly or indirectly for soliciting such exchange. K. The sale of securities by an issuer to fewer than 20 persons in the Philippines during any 12-month period. L. The sale of securities to any number of the following qualified buyers. I. Bank. 2. Registered investment house. 3. Insurance company. 4. Pension fund or retirement plan maintained by the government of the Philippines or any political subdivision thereof or managed by a bank or other persons authorized by the Bangko Sentral to engage in trust functions. V. Investment company or 6. Such other person as the Commission may rule by determine as qualified buyers, on the basis of such factors as financial sophistication, net worth, knowledge and experience in financial and business matters, or amount of assets under management. 10.2. The Commission may exempt other transactions, if it finds that the requirements of registration under this code is not necessary in the public interest or for the protection of the investors, such as by the reason of the small amount involved or the limited character of the public offering. 10.3. Any person applying for an exemption under this section, shall file with the Commission a notice identifying the exemption relied upon on such form and at such time as the Commission by the rule may prescribe, and with such notice shall pay to the Commission fee equivalent to 1/10 of 1% of the maximum value aggregate price or issued value of the securities. Section 11. Commodity futures contracts. No person shall offer, sell, or enter into commodity futures contracts except in accordance with the rules, regulations and orders the Commission may prescribe in the public interest. The Commission shall promulgate rules and regulations involving commodity futures contracts to protect investors to ensure the development of a fair and transparent commodities market. Section 12. Procedure of Registration Securities. 12.1. All securities required to be registered under subsection 8. I shall be registered through the filing by the issuer in the main office of the Commission, of a sworn registration statement with respect to such securities, in such form and containing such information and document as the Commission prescribe. The registration statement shall include any prospectus required or permitted to be delivered under subsections 8.2, 8.3, and 8.4. 12.2. In promulgating rules governing the content of any registration statement, including any prospectus made a part thereof or annexed thereto, the Commission may require the registration statement to contain such information or documents as it may, by rule, prescribe. It may dispense with any such requirements, or may require additional information or documents, including written information from an expert, depending on the necessity thereof or their applicability to the class of securities sought to be registered. 12.3. The information required for the registration of any kind, and all securities, shall include, among others, the effect of the securities issue on ownership, on the mix of ownership, especially foreign and local ownership. 12.4. The registration statement shall be signed by the issuer's executive officer, its principal operating officer, its principal financial officer, its controller, its principal accounting officer, its corporate secretary, or persons performing similar functions accompanied by a duly verified resolution of the Board of Directors of the issuer corporation. The written consent of the expert named as having certified any part of the registration statement or any document used in connection therewith shall also be filed. Where the registration statement shares to be sold by selling shareholders, a written certification by such selling shareholders as to the accuracy of any part of the registration statement contributed to by such selling shareholders shall be filed. 12.5. A. Upon filing of the registration statement, the issuer shall pay to the Commission a fee of not more than 1/10 of 1%, of the maximum aggregate price at which such securities are proposed to be offered. The Commission shall prescribe by the rule diminishing fees in inverse proportion the value of the aggregate price of the offering. B. Notice of the filing of the registration statement shall be immediately published by the issuer, at its own expense, in 2 newspapers of general circulation in the Philippines, once a week for 2 consecutive weeks, or in such other manner as the Commission by the rule shall prescribe, reciting that a registration statement for the sale of such securities has been filed, and that aforesaid registration statement, as well as the papers attached thereto, are open to inspection at the Commission during business hours, and copies thereof, photostatic or otherwise, shall be furnished to interested parties at such reasonable charge as the Commission may prescribe. 12.6. Within 45 days after the date of filing of the registration statement, or by such later date to which the issuer has consented, the Commission shall declare the registration statement effective or rejected, unless the applicant is allowed to amend the registration statement as provided in Section 14 hereof. The Commission shall enter an order declaring the registration statement to be effective if it finds that the registration statement together with all the other papers and documents attached thereto, is on its face complete and that the requirements have been complied with. The Commission may impose such terms and conditions as may be necessary or appropriate for the protection of the investors. 12.7. Upon effectivity of the registration statement, the issuer shall state under oath in every prospectus that all registration requirements have been met and that all information are true and correct as represented by the issuer or the one making the statement. Any untrue statement of fact or omission to state a material fact required to be stated herein or necessary to make the statement therein not misleading shall constitute fraud. Section 13. Rejection and revocation of registration of securities. 13.1. The Commission may reject a registration statement and refuse registration of the security thereunder, or revoke the effectivity of a registration statement and the registration of the security thereunder after the due notice and hearing by issuing an order to such effect, setting forth its finding in respect thereto, if it finds that a. The issuer I. has been judicially declared insolvent. 2. Has violated any of the provision of this code, the rules promulgate pursuant thereto, or any order of the Commission of which the issuer has notice in connection with the offering for which a registration statement has been filed. 3. Has been or is engaged or is about to engage in fraudulent transactions. 4. Has made any false or misleading representation of material facts in any prospectus concerning the issuer or its securities. v. Has failed to comply with any requirements that the Commission may impose as a condition for registration of the security for which the registration statement has been filed, or b. The registration statement is on its face incomplete or inaccurate in any material respect or includes any untrue statements of a material fact required to be stated therein or necessary to make the statement therein not misleading, or c. The issuer, any officer, director, or controlling person performing similar functions, or any underwriter has been convicted, by a competent judicial or administrative body, upon plea of guilty, or otherwise, of an offense involving moral turpitude and/or fraud or is enjoined or restrained by the Commission or other competent or administrative body for violations of securities, commodities, and other related laws. For the purposes of this subsection, the term competent judicial or administrative body shall include a foreign court of competent jurisdiction as provided for under Rules of Court. 13.2. The Commission may compel the production of all the books and papers of such issuer, and may administer oaths to, and examine the officers of such the issuer or any other person connected therewith as to its business and affairs. 13.3. If any issuer shall refuse to permit an examination to be made by the Commission, its refusal shall be ground for the refusal or revocation of the registration of its securities. 13.4. If the Commission deems it necessary, it may issue an order suspending the offer and sale of the securities pending any investigation. The order shall state the grounds for taking such action, but such order of suspension, although binding upon the persons notified thereof, shall be deemed confidential, and shall not be published. Upon the issuance of the suspension order, no further offer or sale of such security shall be made until the same is lifted or set aside by the Commission. Otherwise, such sale shall be void. 13.5. Notice of issuance of such order shall be given to the issuer and every dealer and broker who shall have notified the Commission of an intention to sell such security. 13.6. A registration statement may be withdrawn by the issuer only with the consent of the Commission. Section 14. Amendment to the registration statement. 14.1. If a registration statement is on its face incomplete or inaccurate in any material respect, the Commission shall issue an order directing the amendment of the registration statement. Upon compliance with such order, the amended registration statement shall become effective in accordance with the procedure mentioned in subsection 12.6 hereof. 14.2. An amendment filed prior to the effective date of the registration statement shall recommence the 45-day period within which the Commission shall act on a registration statement. An amendment filed after the effective date of the registration statement shall become effective only upon such date as determined by the Commission. 14.3. If any change occurs in the facts set forth in a registration statement, the issuer shall file an amendment thereto setting forth the change. 14.4. If, at any time, the Commission finds that the registration statement contains any false statement or omits to state any fact required to be stated therein or necessary to make the statements therein not misleading, the Commission may conduct an examination, and, after due notice and hearing, issue an order suspending the effectivity registration statement. If the statement is duly amended, the suspension order may be lifted. 14.5. In making such examination, the Commission or any officer or officers designated by it may administer oaths and affirmations and shall have access to, and may demand the production of, any books, records or documents relevant to the examination. Failure of the issuer, underwriter, or any other person to cooperate, or his obstruction or refusal to undergo an examination, shall be a ground for the issuance of a suspension order. Section 15. Suspension of registration. 15.1. If at any time, the information contained in the registration statement filed is or has become misleading, incorrect, inadequate or incomplete in any material respect, or the sale or offering for sale of the security registered thereunder may work or tend to work a fraud, the Commission may require from the issuer such further information as may in its judgment be necessary to enable the Commission to ascertain whether the registration of such security should be revoked on any grounds specified in this code. The Commission may also suspend the right to sell and offer for the sale such security pending further investigation, by entering an order specifying the grounds for such action, and by notifying the issuer, underwriter, dealer, or broker known as participating in such offering. 15.2. The refusal to furnish information required by the Commission may be a ground for the issuance of an order of suspension pursuant to subsection 15.1. Upon the issuance of any such order and notification to the issuer, underwriter, dealer, or broker known as participating in such offering, no further offer or sale of any such security shall be made until the same is lifted or set aside by the Commission. Otherwise such sale shall be void. 15.3. Upon issuance of an order of suspension, the Commission shall conduct a hearing. If the Commission determines that the sale of any security should be revoked, it shall issue an order prohibiting sale of such security. 15.4. Until the issuance of a final order, the suspension of the right to sell, though binding upon the persons notified thereof, shall be deemed confidential, and shall not be published, unless it shall appear that the order of suspension has been violated after notice. If, however, the Commission finds that the sale of the security will neither be fraudulent nor result in fraud, it shall forthwith issue an order revoking the order of suspension, and such security shall be restored to its status as a registered security as of the date of such order of suspension. Chapter 4. Regulation of Pre-Need Plans. Section 16. Pre-Need Plans. No person shall sell or offer for sale to the public any pre-need plan except in accordance with rules and regulations which the Commission shall prescribe. Such rules shall regulate the sale of pre-need plans by, among other things, requiring the registration of pre-need plans, licensing persons involved in the sale of pre-need plans, requiring disclosures to prospective plan holders, prescribing advertising guidelines, providing for uniform accounting system, reports, and recording keeping with respect to such plans, imposing capital, bonding and other financial responsibility, and establishing trust funds for the payment of benefits under such plans. Chapter V. Repertorial Requirements. Section 17. Periodic and other reports of issuer. 17.1. Every issuer satisfying the requirements in subsection 17.2 hereof shall file with the Commission. A. Within 135 days, after the end of the issuer's fiscal year, or such other time as the Commission may prescribe, an annual report which shall include, among others, a balance sheet, profit and loss statement and statement of cash flows, for such last fiscal year, certified public accountant, and a management discussion and analysis of results of operation, and b. Such other periodical reports for interim fiscal periods and current reports on significant developments of the issuer as the Commission may prescribe as necessary to keep current information on the operation of the business and financial condition of the issuer. 17.2. The repertorial requirements of subsection 17.1 shall apply to the following. A. An issuer which has sold a class of its securities pursuant to a registration under section 12 hereof, provided however, that the obligation of such issuer to file reports shall be suspended for any fiscal year after the year such registration became effective if such issuer, as of the first day of any such fiscal year, has less than 100 holder of such class securities or such other number as the Commission shall prescribe, and it notifies the Commission of such. b. An issuer with a class of securities listed for trading on an exchange, and c. An issuer with assets of at least 50 million pesos, 50 million.00, or such other amount as the Commission shall prescribe, and having 200 or more holder, each holding at least 100 share of a class of its equity securities, provided, however, that the obligation of such issuer to file report shall be terminate 90 days after notification to the Commission by the issuer that the number of its holders holding at least 100 share reduced to less than 100. 17.3. Every issuer of a security listed for trading on an exchange a copy of any report filed with the Commission under subsection 17.1 hereof. 17.4. All reports, including financial statements, required to be filed with the Commission pursuant to subsection 17.1 hereof shall be in such form, contain such information, and be filed at such times as the Commission shall prescribe, and shall be in lieu of any periodical or current reports or financial statements otherwise required to be filed under the Commission shall prescribe. 17.5. Every issuer which has a class of equity securities satisfying any of the requirements in subsection 17.2 shall furnish to each holder of such equity security an annual report in such form and containing such information as the Commission shall prescribe. 17.6. Within such period as the Commission may prescribe preceding the annual meeting of the holders of any equity security of a class entitled to vote at such meeting, the issuer shall transmit to such holders an annual report in conformity with subsection 17.5. Section 18. Reports by 5%. Holders of equity securities. 18.1. In every case in which an issuer satisfies the requirements of subsection 17.2 hereof, any person who acquires directly or indirectly the beneficial ownership of more than 5% of such class or in excess of such lesser percentum as the Commission by rule may prescribe, shall, within 10 days after such acquisition or such reasonable time as fixed by the Commission, submit to the issuer of the securities, to the exchange where the security is traded, and to the Commission, a sworn statement containing the following information and such order information as the Commission may require in the public interest or for the protection of investors. A. The personal background, identity, residence, and citizenship of, and the nature of such beneficial ownership by, such person and all other person by whom or on whose behalf the purchases are effected. In the event the beneficial owner is a juridical person, the of business of the beneficial owner shall also be reported. b. If the purpose of the purchases or prospective purchases is to acquire control of the business of the issuer of the securities, any plans or proposals which such persons may have that will effect a major change in its business or corporate structure. c. The number of shares of such security which are beneficially owned, and the number of shares concerning which there is a right to acquire, directly or indirectly, by such person, and 2. Each associate of such person, giving the background, identity, residence, and citizenship of each such associate, and d. Information as to any contracts, arrangements, or understanding with any person with respect to any securities of the issuer, including but not limited to transfer, joint ventures, loan or option arrangements, puts or call guarantees or division of losses or profits, or proxies naming the persons with whom such contracts, arrangements, or understanding have been entered into, and giving the details thereof. 18.2. If any change occurs in the facts set forth in the statements, an amendment shall be transmitted to the issuer, the exchange, and the Commission. 18.3. The Commission may permit any person to file in lieu of the statement required by subsection 17.1 hereof, a notice stating the name of such person, the shares of any equity securities subject to subsection 17.1 which are owned by him, the date of their acquisition and such other information as the Commission may specify, if it appears to the Commission that such securities were acquired by such person in the ordinary course of his business and were not acquired for the purpose of and do not have the effect of changing or influencing the control of the issuer nor in connection with any transaction having such purpose or effect. Chapter 6. Protection of Shareholders' Interests. Section 19. Tender Offers. Any person or group of persons acting in concert who intends to acquire at least 15% of any class of any equity security of a listed corporation of any class of any equity security of a corporation with assets of at least 50 million pesos, 50 million.00, and having 200 or more stockholders at least 100 shares each or who intends to acquire at least 30% of such equity over a period of 12 months, 12, shall make a tender offer to stockholders by filling with the Commission a declaration to that effect, and furnish the issuer a statement containing such of the information required in Section 17 of this Code as the Commission may prescribe. Such person or group of persons shall publish all request or invitations or tender offer or requesting such tender offers subsequent to the initial solicitation or request shall contain such information as the Commission may prescribe, and shall be filed with the Commission and sent to the issuer not alter than the time copies of such materials are first published or sent or given to security holders. A. Any solicitation or recommendation to the holders of such a security to accept or reject a tender offer or request or invitation for tenders shall be made in accordance with such rules and regulations as may be prescribed. B. Securities deposited pursuant to a tender offer or request or invitation for tenders may be withdrawn by or on behalf of the depositor at any time throughout the period that tender offer remains open, and if the securities deposited have not been previously accepted for payment, and at any time after 60 days from the date of the original tender offer to request or invitation, except as the Commission may otherwise prescribe. C. Where the securities offered exceed that which person or group of persons is bound or willing to take up and pay for, the securities that are subject of the tender offers shall be taken up as nearly as may be pro data, disregarding fractions, according to the number of securities deposited to each depositor. The provision of this subject shall also apply to securities deposited within 10 days after notice of increase in the consideration offered to security holders, as described in paragraph E of this subsection, is first published or sent or given to security holders. D. Where any person varies the terms of a tender offer or request or invitation for tenders before the expiration thereof by increasing the consideration offered to holders of such securities, such person shall pay the increased consideration to each security holder whose securities are taken up and paid for, whether or not such securities have been taken up by such person before the variation of the tender offer or request or invitation. 19.2. It shall be lawful for any person to make any untrue statement of a material fact or omit to state any material fact necessary in order to make the statements made in the light of the circumstances under which they are made, not misleading, or to engage to any fraudulent, deceptive, or manipulative acts or practices, in connection with any tender offer or request or invitation for tenders, or any solicitation for any security holders in opposition to or in favor of any such offer, request, or invitation. The Commission shall, for the purposes of this subsection, define and prescribe means reasonably designed to prevent such acts and practices as are fraudulent, deceptive, and manipulative. Section 20. Proxy Solicitations. 20.1. Proxies must be issued and proxy solicitation must be made in accordance with rules and regulations to be issued by the Commission. 20.2. Proxies must be in writing, signed by the stockholder or his duly authorized representative and filed before the scheduled meeting with the corporate secretary. 20.3. Unless otherwise provided in the proxy, it shall be valid only for the meeting for which it is intended. No proxy shall be valid only for the meeting for which it is intended. No proxy shall be valid and effective for a period longer than 5 years at one time. 20.4. No broker or dealer shall give any proxy, consent, or any authorization, in respect of any security carried for the account of the customer, to a person other than the customer, without written authorization of such customer. 20.5. A broker or dealer who holds or acquire the proxy for at least 10%, or such percentage as the Commission may prescribe of the outstanding share of such issuer, shall submit a report identifying the beneficial owner of 10 days after such acquisition, for its own account or customer, to the issuer of security, to the exchange where the security is traded and to the Commission. Section 21. Fees of tender offers and certain proxy solicitations. At the time of filling with the Commission of any statement required under Section 19 for any tender offer or Section 72.2 for issuer purchases, or Section 20 for proxy or consent solicitation, the Commission may require that the person making such filing pay a fee of not more than 1/10, 1% of 21.1. The proposed aggregate purchase price in the case of a transaction under Section 20 or 72.2, or 21.2. The proposed payment in cash, and ion value of any securities or property to be transferred in the acquisition, merger, or consolidating, or the cash and value of any securities proposed to be received upon the sale disposition of such assets in the case of a solicitation under Section 20. The Commission shall prescribe by rule diminishing fees in inverse proportion to the value of the aggregate price of the offering. Section 22. Internal record keeping and accounting control. Every issuer which has a class of securities that satisfies the requirements of subsection 17.2 shall 22.1. Devise and maintain a system of internal accounting control sufficient to provide reasonable assurance that a. Transactions and access to assets are pursuant to management authorization, b. Financial statements are provided in conformity with generally accepted accounting principles that are adopted by the Accounting Standards Council and the rules promulgated by the Commission with regard to the preparation of the financial statements, and c. Recorded assets are compared with existing assets at reasonable intervals and differences are reconciled. Section 23. Transactions of directors, officers and principal stockholders. 23.1. Every person who is directly or indirectly the beneficial owner of more than 10% of any class of any equity security which satisfies the requirements of subsection 17.2, or who is a director or an officer of the issuer of such security, shall file, at the time either such requirement is first satisfied or after 10 days after he becomes such a beneficial owner, director, or officer, a statement form the Commission and, if such security is listed for trading on an exchange, also with the exchange of the amount of all the equity security of such issuer of which he is the beneficial owner, and within 10 days after the close of each calendar month thereafter, if there has been a change in such ownership at the close of the calendar month and such changes in his ownership as have occurred during such calendar month. 23.2. For the purpose of preventing the unfair use of information which may have been obtained by such beneficial owner, director, or officer by reason of his relationship to the issuer, any profit realized by him from any purchase or sale, or any sale or purchase, of any equity security of such issuer within any period of less than 6 months unless such security was acquired in good faith in connection with a debt previously contracted, shall inure to and be recoverable by the issuer, irrespective of any intention of holding the security purchased or of not repurchasing the security sold for a period exceeding 6 months. Suit to recover such profit may be instituted before the regional trial court by the issuer, or by the owner of any security of the issuer in the name and in behalf of the issuer if the issuer shall fail or refuse to bring such suit within 60 days after request or shall fail diligently to prosecute the same thereafter, but not such shall be brought more than 2 years after the date such profit was realized. This subsection shall not be construed to cover any transaction where such beneficial owner was not such both time of the owner or the sale of purchase, of the security involved, or any transaction or transactions which the Commission by rules and regulations may exempt as not comprehended within the purpose of this subsection. 23.3. It shall be unlawful for any such beneficial owner, director, or officer, directly or indirectly, to sell any equity security of such issuer if the person selling the principal, a. does not own the security sold, or, b. if owning the security, does not deliver it against such sale within 20 days thereafter, or does not within 5 days after such sale deposit in the mails or the unusual channels of transportation, but no person shall be deemed to have violated this subsection if he proves notwithstanding the exercise of good faith he was unable to make such delivery in such time, or that to do so would cause undue inconvenience or expense. 23.4. The provisions of subsection 23.2 shall not apply to any purchase and sale, or sale and purchase, and the provisions of subsection 23.3 shall not apply to any sale of an equity security not then or thereafter held by him and an investment account, by a dealer in the ordinary course of his business and incident to the establishment or maintenance by him of a primary or secondary market, otherwise than on an exchange, for such security. The Commission may, by such rules and regulations as it deems necessary or appropriate in the public interest, define and prescribe terms and conditions with respect to securities held in an investment account and transactions made in the ordinary course of business and incident to the establishment or maintenance of a primary or secondary market. Chapter 7. Prohibitions and Fraud, Manipulation, and Insider Trading. Section 24. Manipulation of security prices, devices and practices. 24.1 It shall be unlawful for any person acting for himself or through a dealer or broker, directly or indirectly, a. to create a false or misleading appearance of active trading in any listed security traded in an exchange of any other trading market, hereafter referred to purposes of this chapter as exchange. I. By effecting any transaction in such security which involves no change in the beneficial ownership thereof. 2. By entering an order or orders for the purchase or sale of such security with the knowledge that a simultaneous order or orders of substantially the same size, time, and price, for the sale or purchase of any such security, has or will be entered by or for the same or different parties, or 3. By performing similar act where there is no change in beneficial ownership. b. To affect, alone or with others, a securities, or transactions in securities that, I. raises their price to induce the purchase of a security, whether of the same or a different class of the same issuer or of controlled, or commonly controlled company by others, or 3. Creates active trading to induce such a purchase or sale through manipulative devices such as marking the close, painting the tape, squeezing the float, hype and dump, boiler room operations and such other similar devices. c. To circulate or disseminate information that the price of any security listed in an exchange will or is likely to rise or fall because of manipulative market operations of any one or more persons conducted for the purpose of raising or depressing the price of the security for the purpose of inducing the purpose of sale of such security. d. To make false or misleading statement with respect to any material fact, which he knew or had reasonable ground to believe was so false or misleading, for the purpose of inducing the purchase or sale of any security listed or traded in an exchange. e. To effect, either alone or others, any series of transactions for the purchase and or sale of any security traded in an exchange for the purpose of pegging, fixing, or stabilizing the price of such security, unless otherwise allowed by this code or by rules of the Commission. 24.2. No person shall use or employ, in connection with the purchase or sale of any security, any manipulative or deceptive device or contrivance. Neither shall any short sale be effected nor any stop-loss order be executed in connection with the purchase or sale of any security except in accordance with such rules and regulations as the Commission may prescribe as necessary or appropriate in the public interest for the protection of investors. 24.3. The foregoing provisions notwithstanding, the Commission, having due regard to the public interest and the protection of investors, may, by rules and regulations, allow certain acts or transactions that may otherwise be prohibited under this section. Section 25. Regulation of option trading. No member of an exchange shall, directly or indirectly endorse or guarantee the performance of any put, call, straddle, option or privilege in relation to any security registered on a securities exchange. The terms put, call, straddle, option, or privilege shall not include any registered warrant, right or convertible security. Section 26. Fraudulent transactions. It shall be unlawful for any person, directly or indirectly, in connection with the purchase or sale of any securities to 26.1. Employ any device, scheme, or artifice to defraud. 26.2. Obtain money or property by means of any untrue statement of a material fact, of any omission to state a material fact necessary in order to make the statements made, in the light of the circumstances under which they were made, not misleading, or 26.3. Engage in any act, transaction, practice, or course of business which operates or would operate as a fraud or deceit upon any person. Section 27. Insider's duty to disclose when trading. 27.1. It shall be unlawful for an insider to sell or buy a security of the issuer, while in possession of material information with respect to the issuer or the security that is not generally available to the public, unless, a. the insider proves that the information was not gained from such relationship, or, b. if the other party selling to or buying from the insider, or his agent, is identified, the insider proves, I. that he disclosed the information to the other party, or, 2. that he had reason to believe that the other party otherwise is also in possession of the information. A purchase or sale of a security of the issuer made by an insider defined in subsection 3.8, or such insider's spouse or relatives by affinity or consanguinity within the second degree, legitimate or common law, shall be presumed to have been effected while in possession of material non-public information if transacted after such information came into existence but prior to dissemination of such information to the public and the lapse of a reasonable time for market to absorb such information. Provided, however, that this presumption shall be rebutted upon a showing by the purchaser or seller that he was aware of the material non-public information at the time of the purchase or sale. 27.2. For purposes of this section, information is material non-public if, a. it has not been generally disclosed to the public and would likely affect the market price of the security after being disseminated to the public and the lapse of a reasonable time for the market to absorb the information, or, b. would be considered by a reasonable person important under the circumstances in determining his course of action whether to buy, sell, or hold a security. 27.3. It shall be unlawful for any insider to communicate material non-public information about the issuer or the security to any person who, by virtue of the communication, becomes an insider as defined in subsection 3.8, where the insider communicating the information knows or has reason to believe that such person will likely buy or sell a security of the issuer whole in possession of such information. 27.4. A. It shall be unlawful where a tender offer has commenced or is about to commence for I. any person, other than the tender offerer, who is in possession of material non-public information relating to such tender offer, to buy or sell the securities of the issuer that are sought or to be sought by such tender offer if such person knows or has reason to believe that the information is non-public and has been acquired directly or indirectly from the tender offerer, those acting on its behalf, the issuer of the securities sought or to be sought by such tender offer, or any insider of such issuer, and 2. Any tender offerer, those acting on its behalf, the issuer of the securities sought or to be sought by such tender offer, and any insider of such issuer to communicate material non-public information relating to the tender offer to any other person where such communication is likely to result in a violation of subsection 27.4, a. I. b. For purposes of this subsection, the term securities of the issuer sought or to be sought by such tender offer shall include any securities convertible or exchangeable into such securities or any options or rights in any of the foregoing securities.